Let me present some of the important point in reference to partition. All legal heirs, including the daughters, will inherit equal shares in an ancestral property or the joint family property. When the partition is effected, the daughters are also equally entitled for the equal share as that of the sons. However, when the partition takes place amongst brothers, sisters, amongst the family members who are jointly living, once the partition is effected, then there is a full stop for the joint family system. That joint family is dissolved. It becomes the independent shareholders, and those independent shareholders, which is devolved from their ancestral rights, becomes their self-earned property then. So this is about the partition. This partition is only for the ancestral property, whereas the self-acquired property need not be partitioned. Self-acquired property, the rights is held by the person who has earned with his skills, and it is his will and wish to whom he should give the property. If the father has earned a self-acquired property, it is his will, his wish to give that property to anybody of his choice. It may be his own family members, or it can be even outsiders. He can pass it on to anybody he likes, either during his lifetime or through a will. Only in case of intestate death, if a person who owned a self-earned property passes away, he dies intestate, that is to say without making a will, then all his legal heirs are equally entitled for their respective shares in the property of the father, which was self-earned but he passed away intestate. Whereas partition is only for the ancestral property. That will stop. Once the partition is effected, the joint family is dissolved. Whereas in a self-earned property, the person who is owning the property can write it off, can pass it off to anybody of his choice. There can be no partition effected as far as the self-earned property is concerned.